Hello, my name is Vicki Gillen, and I am a senior attorney with the Denver Regional Office of the Federal Labor Relations Authority. Today I will be discussing discrimination under the Federal Service Labor Management Statute. After completing this session, if you have further questions, you may wish to visit our website at FLRA.gov to review authority decisions, as well as the Office of the General Counsel's case law outline. Let's begin. When we are talking about discrimination, we are referring to discrimination as defined in the Federal Service Labor Management Statute, which I will refer to as the statute here on in. Under the statute, it is unlawful for a federal agency to discriminate against a federal employee for exercising their protected rights under the statute. In order to understand discrimination based on employees' protected rights, let's begin with a quick review of those protected rights. For a more in-depth review of protected rights under the statute, please review our training presentation on unlawful interference, which provides additional examples and discusses the concept of flagrant misconduct. Section 7102 of the statute defines employees' rights, stating that each employee shall have the right to form, join, or assist any labor organization or to refrain from such activity freely and without penalty or reprisal, and each employee shall be protected in the exercise of such right. These rights under Section 7102 include the right for an employee to act as a representative of a labor organization or union, the right for an employee to present the views of a union to agency heads, executive branch officials, the Congress, and other appropriate authorities. It also includes that employees may engage in collective bargaining with an agency. Of course, employees have the right to engage in such matters, but if you remember, Section 7102 also gives employees the right to choose to refrain from engaging in them as well. Employees' rights under Section 7102 of the statute are more commonly referred to as protected activity, in that the statute provides for specific protection of employees while engaging in activities in conjunction with a protected employee right. Some examples of protected activity under Section 7102 include representing a union by holding a leadership or representational position. Protected activity also includes an employee filing, processing, and pursuing grievances. That right also includes the right to gather evidence in support of such grievances, or an unfair labor practice against an agency for an allegation of a violation of the statute. An unfair labor practice is usually known as a ULP. Some additional protected activity under the statute includes an employee assisting in organizational campaigns for a union, engaging in various solicitation activities on behalf of a union, and seeking assistance from a union to file a grievance and obtain the union's representation. Protected activity under Section 7102 also includes an employee exercising or asserting a right under a collective bargaining agreement, as well as discussing the collective bargaining agreement with other union representational matters in the workplace, so long as it's done during non-work time where it does not disrupt work. So by now, we have gone over the fact that federal employees have certain rights under the statute. Specifically, Section 7102 of the statute gives employees the right to form, join, or assist any labor organization, and conversely, the right to not form, to not join, or not assist a labor organization. We know that there are many activities that an employee can engage in while exercising those protected rights. We call such activities protected activity. Now we are ready to discuss discrimination based on an employee engaging in protected activity, which is covered in Section 7116A2 of the statute, as well as Section 7116A4 of the statute. We have two parts of the statute that define discrimination against protected activity by an agency. The first section, Section 7116A2, states that it is an unfair labor practice charge, or ULP, for an agency to encourage or discourage union membership in a labor organization by discriminating in connection with hiring, tenure, promotion, or other conditions of employment. The second section, Section 7116A4 of the statute, states that it is an unfair labor practice, a ULP, for an agency to discipline or otherwise discriminate against an employee because the employee has filed a complaint, affidavit, or petition, or has given any information or testimony under the statute. So we have two separate types of discrimination in Section 7116A2 and Section 7116A4. In order to understand each of these two types, let's look at what kinds of discrimination each section prohibits. First, Section 7116A2 prevents discrimination against federal workers engaged in union activities. Union activities is going to include the protected activities that we've discussed earlier. So for an example, if an agency fails to promote an employee and the reason they do not promote that employee was because of the employee's union activities, the agency would be in violation of Section 7116A2 of the statute. Next, Section 7116A4 protects people who are cooperating with the FLRA in investigations or representational matters, or people who have filed a charge with the authority. For example, if an agency disciplines an employee because she gave testimony at an FLRA hearing, such as a ULP hearing, or disciplined her for cooperating in an FLRA investigation, such as providing information and evidence during a ULP investigation process, the agency would be in violation of Section 7116A4. If we remember from our discussion involving Section 7102, employee rights under the statute, employees have the right to form, join, or assist any labor organization. And employees also have the right to refrain from forming, joining, or assisting any labor organization. Accordingly, Section 7116A2 and Section 7116A4 of the statute prohibit discrimination for not engaging in union activities. We know that the statute prohibits an agency from discriminating against employees under both Section 7116A2 and 7116A4. So now we need to know, how do we determine if an agency has discriminated against an employee under either of those sections? The authority has established a test to determine if the facts and circumstances of a case establish the baseline requirements to prove discrimination under the statute. Establishing a case that meets these baseline requirements is referred to as an establishing a prima facie case. And if we think about how this test for discrimination would play out, we would have a charging party, so a union or an individual who's protected under the statute, who files an unfair labor practice charge with the FLRA, alleging that an agency violated Section 7116A2 and or Section 7116A4 by discriminating against an employee for engaging in protected activity. Once that ULP charge is filed, the FLRA's Office of the General Counsel will start an investigation to determine if there was a violation of the statute. So if the General Counsel, through its attorneys in the regional offices, such as myself, are trying to allege that an agency discriminated against a union or an employee, the General Counsel would first need to establish that the case meets the baseline requirements. So the General Counsel has to establish a prima facie case for discrimination. In order to establish that prima facie case, the General Counsel, through the assistance of the union or the person who filed the discrimination charge, that ULP, would need to establish three things. First, the alleged discrimination involved an employee who is engaged in protected activity. So an employee who is at least engaging in at least one of the rights under Section 7102. Next, the circumstances of the case must include that an agency took a discriminatory action. And finally, third, and this is often the tricky one, it must be proven, or at least established, in the case that the employee's protected activity was a motivating factor in the agency's discriminatory treatment of the employee. So these three requirements, the three baseline requirements that the General Counsel must establish in order to make a case that an agency discriminated against an employee in violation of the statute. The employee engaged in protected activity, agency took a discriminatory action, and the employee's protected activity was the motivating factor. Those three requirements are needed to establish a prima facie discrimination case. It is the first part of the authorities test, which comes from this 35-volume case called, or most recently, or I guess referred to as, Letterkenny. So in this Letterkenny test, we see we have those three requirements at first, but that's not where the test ends. Under the Letterkenny test, establishing those three elements of a prima facie case requires an examination of the facts and circumstances of the specific case. The authority in the Letterkenny case identified several factors that should be reviewed when trying to determine if the employee's protected activity was involved in the agency's decision of its treatment against the employee. Such factors include, was there protected activity? So we think back to Section 7102. Was protected activity being engaged in by the employee? Was the agency aware of the protected activity? This will depend on the type of protected activity involved. But say an employee alleges that the agency discriminated against him because he was a union representative. This is a good place to start to determine if the agency would be aware that this employee, or should have been aware that this employee, was a representative. Things to look at would be, did the union send the agency a list of its representatives? Had that employee been involved in union-related matters with members of management in the past, and so forth. Another factor is, was there discriminatory action taken against the employee? The alleged action by the agency needs to be identified and defined. Without an action, obviously, we will not be able to prove discrimination. We would next look at how were other employees who were not engaged in protected activity treated. You will hear this referred to as finding similarly situated employees. Under Letterkenny, it is helpful to know if, say, there were 10 employees all eligible for overtime, and 9 employees, all 9 were not engaged in protected activity, were constantly offered overtime. But management refused to offer overtime to that one other employee who just so happened to be the union president, involving in contentious collective bargaining negotiations. This would be important to know, and it would be considered part of the test to be weighed in determining whether discrimination has occurred. Next, we would look at, would the action have been taken by the agency in the absence of protected activity. This is where we play the but-for game. Based on the facts and circumstances, would the agency have taken the same action against the employee but for the employee's protected activity? Next, we would look at, is there evidence of anti-union animus? Anti-union animus is conduct that expresses dislike, disagreement, and/or disrespect against the union. So if there had been a statement or actions by the agency surrounding the alleged discrimination that related to an expression against the union, it would be important to consider that when looking at this specific discrimination charge. If you have reviewed our training on unlawful interference, you may recall the anti-union animus being part of our discussion of the section 7116A1 of the statute, unlawful interference by an agency. The last factor that we look at is, was the protected activity a motivating factor in the discriminatory action? This factor, or rather question, is a pretty tough one, but the other Letterkenny factors can give us evidence to be able to weigh towards whether or not the protected activity was that motivating factor by the agency in their action against this employee. We've discussed the General Counsel needing to establish a prima facie case by showing the three parts under the Letterkenny test. In a quick review, that is, 1, was the employee engaged in protected activity? 2, did the agency take a discriminatory action against the employee? And 3, was the employee's protected activity a motivating factor for the agency in taking such action? So if the General Counsel cannot show all three of those requirements, the case is done. Discrimination by the agency cannot be found. But if the General Counsel can show all three of those requirements under the Letterkenny test, the authority will find that the agency violated the statute by discriminating against an employee unless, and I'm pausing for dramatic effect here, unless the agency can prove that it had a legitimate reason for the action it took. So first, the General Counsel has the burden of showing those three prongs under Letterkenny. But if the General Counsel meets that burden, the burden then shifts to the agency to show that it had a legitimate reason for taking such an action against an employee. It's now the agency's turn to establish their case. So if the agency can establish that it took the action against an employee for a reason other than protected activity, the burden then shifts again, this time back to the General Counsel. The General Counsel would then have the burden of showing that the reason the agency gave for taking the action was pretextual, and it ultimately took the action because of the protected activity by the employee, not the reason that the agency gave. All right, so if we play this whole Letterkenny test out, we start with the General Counsel, who has the burden of establishing the three factors under Letterkenny for a prima facie case of discrimination. If they can establish those three things, the General Counsel then moves the burden to the agency to show that it took the action for a legitimate reason. If the agency cannot sufficiently prove that it took the agency for a legitimate reason, the case is over, there's no violation. But if the agency does establish that it took the action for a legitimate reason, the burden then shifts back to the General Counsel to prove the legitimate reason the agency provided was pretextual. If the General Counsel cannot show that the agency's legitimate reason was pretextual, the case is over, there's no violation. But if the General Counsel can show that the agency's legitimate reason was pretextual, we have a situation where then there can be the possibility for discrimination, as the agency's real reason was based on protected activity, which would be discrimination. We have a lot of burden shifting going on here. I like to refer to it as the Letterkenny tennis game, where the burden goes back and forth and then back again. Let's look at some examples where the authority found discrimination. First, an agency denied an employee a flight assignment based on an email he sent in his capacity as a union steward. In this case, the employee, who part of his job was to be assigned to different flight assignments to gain different experience, had emailed the agency in his capacity as a union representative and expressed his concern regarding employee safety. It was after sending the email that this employee learned that the agency had taken him off of an upcoming flight because of his voicing his concerns against the agency. Here, the authority had the evidence, and they found that the agency removed the employee from the upcoming flight schedule because they did not like the employee's comments regarding employee safety, i.e., the employee engaging in protected activity, and such an action was discrimination against the employee for engaging in protected activity. In the next case, an employee was in the process of becoming trained to serve as a victim advocate. During the time the employee was still training, they decided to become a union steward. Prior to the employee beginning her role in the victim advocate position, she requested from her supervisor to arrange an official time schedule. Her supervisor responded that he denied her request for official time and that the employee could not serve as the victim advocate and be a union steward, and required the employee to choose between the two. The authority found that the general counsel established a prima facie case of discrimination. So, the employee was engaged in protected activity by serving as a union representative and by requesting official time to serve in her steward capacity. Next, the general counsel showed that the agency took an action against the employee by denying her the opportunity to serve as a victim advocate and a union steward, also by asking her to choose or forcing her to choose. And then finally, the general counsel established that the agency was motivated by the employee's protected activity when it forced the employee to decide between serving as a victim advocate and serving as a union steward. The authority also found that the agency did not establish a legitimate justification for requiring the employee to choose between the two, so the victim advocate and the union steward. Therefore, the authority found that the agency violated the statute by discriminating against the employee for engaging in protected activity. Let's look at what the authority is specifically looking for when it looks at questions of mixed motive. So here there are multiple reasons why an agency took an action against an employee. We call that mixed motive. If an agency has one or more reasons for taking an action against an employee, the authority will find that the agency did not violate the statute if, and only if, pausing again for dramatic effect, if and only if the agency can prove both that the agency had a legitimate reason for the action it took against the employee and the agency would have taken the action against the employee even if the employee had not engaged in protected activity. Let's take a look at an example. In a 35-volume authority decision, a union representative received an overall rating of excellent while he was serving roughly 15% of his duty time engaged in union activities. The next year, the employee was engaged in roughly 45% of his duty time in union activities and received a lower performance rating of fully successful. Here, the supervisor told the employee that he received a lower rating because they could not depend on the employee because he was always gone doing a lot of union activities. The authority found here that the agency did not establish a legitimate justification for giving the employee a lower rating, as the agency had no documentation or evidence to demonstrate that the employee's performance actually declined. In this case, we have an example where the authority found that the agency had not violated the statute because the agency had a legitimate reason for moving an employee after the employee filed a grievance. In this case, an employee filed a grievance regarding a hostile work environment. The agency, as it presented before the courts, had evidence that it moved that employee following the filing of his grievance based on concern for the employee's safety. Remember, that grievance was about a safety issue within the work environment. Here, the authority found that the legitimate justification by the agency was proper and that there was no violation under the statute. Let's review one example before we wrap up our discussion on discrimination. Here, the president of the local union submitted a request to attend training. This training request was approved by the agency. The union president then filed a ULP against the agency on an unrelated matter. 1 week after the charge was filed, approval of the training request was withdrawn, and the request was disapproved. Do we have a violation? Here, the timeline is pretty important. We see that the employee is approved for the training, and then only after the ULP is filed does that training become disapproved. We also look at that obviously the filing of a ULP by a union president is protected activity, and management took this action, i.e. withdrawing their approval of the employee's training, that would negatively affect that employee by not being able to participate in that training. So clearly, the protected activity was a motivating factor in the act of withdrawing the approval for this training request, and we would have a violation of the statute 7116A2. So to review, when you're looking at matters of discrimination, either under section 7116A2 or 7116A4 of the statute, we look to Letterkenny. Under Letterkenny, we have 3 prongs that we must meet if we are the general counsel or any party who's trying to put their case together. The 3 prongs under Letterkenny are: do you have an employee engaged in protected activity? Do you have the agency taking an action against an employee? And finally, is the employee's protected activity a motivating factor of the agency's decision to take that action? As we reviewed, proving discrimination, it tends to be a burden-shifting process. It's not enough for the general counsel to be able to show this prima facie case. After a prima facie case of discrimination is established, the agency has an opportunity to respond and prove that a legitimate reason it took a legitimate reason in making that action. Finally, if that is established, general counsel has one more opportunity to prove that the legitimate reason was pretextual and was not the real reason the agency took that action. It's a very complicated and in-depth process in proving discrimination, but as you saw today, breaking it down into little pieces and understanding that it's a case-by-case review, that is the beginning of being able to not only appreciate Section 7116A2 and 7116A4 of our statute, but also to appreciating how our statute works in the context of other violations such as 7116A1, as well as others. I thank you for your time today. I appreciate your time and attention. There is a survey following this presentation to get your thoughts on this training, and it would be very helpful. So go ahead and select the Take the Training Survey button when you're done, and thank you.